afternoon, dear participants of the venue in Ukraine Crisis Media Center. Today we are talking about very important, very relevant topic for Ukraine and for our partners. Today we are talking about Russian petty demands and the imposition of, in fact, permanent neutrality and disarmed neutrality on Ukraine as a condition for peace or so-called peace. All these Russian petty demands are, of course, still up in the air, but nevertheless, unfortunately, the issues we are discussing today, the imposition of neutrality on Ukraine is mentioned in, as Russians say, in several documents, and recently they have published a memorandum where the position, the demand of disarmed neutrality goes right after the territorial seizure through international legal means. And after that we have the issue of disarmament and the issue of Ukraine's nuclear status, which they also want to consolidate forever so that Ukraine couldn't discuss these topics. Let me remind, even though Ukrainian side states that it doesn't mean anything, that it's just a paper, but in Istanbul, back in 2022, the demand was the same, and it was called this pro-Russian vision, even though we saw it only in publications of foreign media. And it was called Memorandum on Agreement on Permanent Neutrality and Security Guarantees for Ukraine. You remember everyone was saying that it's about security guarantees, but first of all it was about the permanent neutrality, and if we do not accept this text as a document, even a kind of initialed document, nevertheless it's Russian vision which we did not accept back that time, but we are facing the second attempt, and they will continue their attempts. So this memorandum, which now Russians have suggested, it was sent to the US, and I have checked, indeed there is this kind of demand. Everyone who is insisting on the Russian narrative, so they use the fact that in the declaration on the state sovereignty of Ukraine there was a provision which stated that in the future Ukraine will become neutral state, and the same provisions we can see in the draft agreement from the Russian Federation. The same position is justified in many sources, and I do not know whether my colleagues have seen this book or not, but for the first time I see this book, quite a big monography, even though the part of this monography is sources, namely Russian ones, and that is historical aspect. But I have conducted my small research and understood why this monography, quite an old one, as of 2005, and that is our colleague specialized in international law. But the main thing here is the foreword. In the foreword, referring to the declaration on the state sovereignty of Ukraine and ignoring the immense to the basic documents, including Constitution of Ukraine, where all of these issues were resolved long time ago and no one is discussing this matter at all. But here, right in the beginning, we can read that neutrality must be disarmed. Neutrality must be recognized by politicians as the only option for Ukraine. Ukraine was not disarmed. Ukraine has to undertake these steps, and there should be no burden for the budget for modernization of weapons. Also there is a recommendation to have the permanent neutrality. You know who wrote it? A very interesting person, the chairman of the subcommittee on economic security, defense, industry and military cooperation, Committee of National Security and Defense of the Verkhovna Rada of Ukraine. Does it sound good? Yes, it is. Vladimir Sevkovich, FSB agent, according to General Malamush, and I trust his trust. He's the head of the Foreign Intelligence Service, a person subject to not only national but also international sanctions, and all of it. It's not just science, it's Russian PSYO, which started according to, and I would like to thank for that, we were discussing that, Mr. Butkevich, one of the best specialists, not only in Ukraine, in the International Human Rights Court, professor, that this neutrality issue was dropped from Moscow in Ukraine, and it was an element of frustration of Moscow after the collapse of the Russian Federation to keep Ukraine in the hanged position. And what is the most important here, it was made from where? From KGB. Once again, that is Soviet and later Russian special services, which dropped this narrative here. The neutral state can be the state which is strong, the state with a strong army, with strong military position. The state which is weak, it has no opportunities for neutrality. It will be consumed by the stronger ones if the state will declare neutrality. And once again, we refer to the current situation. Ukraine is not a weak state. Ukraine is not even in the military means a weak state. But nevertheless, Ukraine has this kind of weakness due to its geopolitical position and due to the fact that we border with aggressor state, with the state which is historical aggressor, which wants to destroy Ukraine. And as for Ukraine and Ukrainian neutrality, typically, proponent, the ones who support neutrality for Ukraine, they make the line of three documents: a declaration on the state sovereignty of Ukraine, Act of Independence, and Constitution of Ukraine. Let me explain why. Declaration on the state sovereignty of Ukraine is in fact the only document which mentions the permanent neutrality of Ukraine. And then it is stated that the Act of Independence was made according to the implementation of declaration, and the Constitution of Ukraine mentioned the Act of Independence, and therefore Constitution has to have these provisions. Let's see what do we have in the declaration on the state sovereignty of Ukraine. There we have lots of different provisions, and I cannot say that it's 50%, but around 50% provisions which meet the realms of that time, which are outdated at the moment. The provisions on the citizenship of the Soviet Union, provisions on the fact that Ukrainian citizens typically has to serve in Ukrainian army, the provisions regarding the armed forces of Ukraine, which are absent there. So in fact, that is a declaration of Ukrainian Soviet Ukraine. The second question regarding declaration, and once again, the proponents, the agitators for permanent neutrality of Ukraine, they state that declaration was the grounds for the Constitution of Ukraine. And I suggest them to read what is written later. The principles of sovereignty goes in the grounds of the Union Agreement. So it means that at that time there was absolutely different situation, absolutely different geopolitical situation. As for the grounds for the Constitution, it would have been better if these agitators for the permanent neutrality, it would have been better if they saw the other provisions which are not in the Constitution. The provision which is very relevant for a declaration and which states that Ukraine admits priority of generally recognized norms of the international law, and they prevail over the national law. And it's not in the Constitution, but it's not something that is interesting for the supporters of the permanent neutrality for Ukraine, because it doesn't meet the Russian demands. And in the Russian Federation, they do the same thing. They do not want to add it to Tropin. Yes, they excluded it. And in fact, it does not meet their demands. And once again, speaking of declaration, this declaration was made for that time. And as you have mentioned, it is stated that Ukraine has an intention to become the permanent neutral state in the future. And intention is not something that is a clear position. And second of all, in the future, future is when we are lawyers. So what is future? What is a timeline? And in fact, international law is a system which is a living document, which is adjusting to the reality, which is the evolution system, and it is stated by the international courts, which sometimes make the decisions which are different from the decision they made 20 years ago, because the world has changed and international law has changed as well. And therefore, today I'm not going to say that what has changed since that times, but I can say that the Soviet Union disappeared, and that is a huge tectonic change in the international affairs. And beside that, speaking of the Declaration of the State Sovereignty of Ukraine, we can talk about the fundamental changes of the situation. After 1990s, the Soviet Union ceased existed, and the configuration has changed, the security and international affairs. And once again, through these rebus extenticus fundamental changes, these provisions cannot be applied. Then they are talking about the Act of Independence, and here we have one position. The Act of Independence was made for the implementation of declaration. Implementation is not the automatic implementation of all the positions of the Declaration on the State Sovereignty. It means that we are talking about the rule of law on the territory of Ukraine, and finally constitution of Ukraine, which is mentioned here, and everything here is even simpler. Constitution states clearly Euro-Atlantic integration of Ukraine, meaning that the legislation means exactly the same thing. And one more important thing, after declaration on the state sovereignty of Ukraine, there was no law or no bylaw which would have stated the position on neutrality of Ukraine. Let me remind you what was said before. Some time ago, there was an attempt with Russian pressure to make the draft constitution to have a separate chapter, as far as I remember, chapter number 20 on neutrality of Ukraine, something that Russians are demanding now. And at that moment, the head of the commission, Volodymyr Butkevich, and before him, there was a preparation for this in 1991. And at that moment, the arguments were not just the ones which were mentioned, but there were also other arguments, and they did not add the chapter. This chapter was not in the draft, meaning that even some idea which we can accept, okay, there were different ideas to continue it, but nobody continued it. And we can say that Constitution clearly does not accept this idea, considering the new realities. And now we have the intention there to be in coalition. Let's not forget that Constitution, which should have been based and is based on the basic foundations on the state sovereignty, because it is a very important program document, and it has never had any thesis provisions on neutrality, and it has the highest supreme legal force. And after the amendments as of 2019, we have Euro-integrational aspect there. And what you have, Mr. Valeriy, mentioned, it is, I also saw the project, the draft of the permanent neutrality as of 2007, written by Nestor Shulevich. And the first provision, which we can see in here, and it is also mentioned in Istanbul Agreement and Memorandum suggested in 2025. But I was shocked even more by provision about the armed forces of Ukraine. And it is said, I cannot quote you, but it has to be minimum sizes required for defense. So in 2007, they wanted us to have small armed forces just for defense, because now all of us are just smiling when we hear these words. And everyone who was behind this idea, behind this draft, they did not consider that it will work out. In 2000 2010, everything was much smarter. Neutrality was not discussed that much, and in the law, in the new law on the internal and external policy, it was written the provision of non-block status, and later it was changed on the clear direction to Euro integration, NATO integration. And if you don't mind, I'd like, as a participant of those events, let me remind you how it happened, because I was the head of this group which was preparing these amendments to the legislation and the law, and its part on the external policy. First of all, the draft was approved within the ministries, in the Ministry of Foreign Affairs, and then it was sent to Yanukovych president, and then he has approved, be careful, he has approved it, so Euro integration, the same perspectives in the future, and a statement that Ukraine is a non-block state, and in the future it will be considering the situation from the from the perspective of the best interests of Ukraine. All of us, we came there, and me as the deputy minister, we were so happy. And in 10 days, he received another task, and as far as I know, they have checked these documents in Moscow and told to change it. And then we had opened and classified documents and orders, and in my case, that was the reason why I quit my position. And you're absolutely right, but let me remind you that before that, we had the attempts, and both in the military doctrine, since 2002, the State Security Council had the idea to be in NATO in 2008. Let me remind you just this fact. And what also interesting, there is Our Way to Europe in English, signed by President Yanukovych. He didn't know that. He was concerned that his name was nowhere, and he replaced his name in this book. And in 2008, Ukraine was ready for NATO, and everyone was moving towards this cooperation. And therefore, we had Tuzla in 2003, and after that, we had Zakhar. And all of these things are interrelated. If we consider Ukrainian situation, what is the advantage of neutrality? We can say that it's the end of the war, but it's almost impossible, and that it will stop the Russian aggression. And the rest is disadvantages. The rest is some disadvantages. And the main disadvantage is that in our situation, of course, that is something that international affairs analytics can be discussing, and they know it better. The main disadvantage is that the implementation of neutrality in Ukraine will just encourage the Russian Federation for further aggression against Ukraine. And in this context, why do we have the parade of refusals to be neutral? Because the states, they feel these risks, and therefore Ms. Olga has stated it really right in the beginning, that neutrality, even though it is typically stated by the state itself, it has to be respected by the other states. And if the situation turns out in the way that the other states do not support this neutrality or do not respect this neutrality, in this case, neutrality doesn't mean anything. Let me remind you, Germany has attacked France through Belgium and Luxembourg, which used to be neutral. So neutral status of these states did not stop Germany from aggression against France and from aggression against other states. And therefore, and even among those states which were listed neutral or partially neutral ones, there is still an issue regarding whether they are neutral, whether they are recognized as neutral, because there are the states which stated that they are neutral. There are the states which have stated in some international agreements that they are neutral. There are the states which said that they are neutral, but the other states do not recognize them as neutral. And therefore, it is the question of neutrality, because neutrality is also the bilateral relation, because the other states have to recognize it, support it, and respect it. And if we are talking about these, so to say, refusals to become neutral, and if we consider the situation in Ukraine and the risks, first of all, the main risk for Ukraine is that neutrality in Ukraine will not be a guarantee that we will not face aggression from the Russian Federation. On the contrary, that will encourage the Russian Federation to be aggressive against Ukraine. There is another issue. It's about the neutrality when Ukraine is forced to be neutral, when Ukraine is not doing it because volunteers to be neutral, but when Ukraine is forced to be neutral, and when Ukraine has to state that it's neutral, although Ukraine doesn't want to do that. And what do we not even what do we consider to be neutral, and but what the Russian Federation as aggressor means by neutrality? Our colleagues have mentioned it. Neutrality is quite an old institute, and legally speaking, the last documents is Hague Convention 1889 and 1907, and then we only had the practical implementation of neutrality, and that were the statements of different states and documents. But on the level of the legislation and international law, what is neutrality and what do we mean by neutrality? In there is Hague Convention 1769 and 1896, and how the perception has changed. And if we are talking about neutrality and about what do we mean by neutrality, the Russian Federation doesn't determine it even in the way how Hague Convention mentioned it. For the Russian Federation, neutrality is disarmament of Ukraine, even though they say write it in two separate provisions and two separate demands, but in fact, they want us not to be neutral. If we rephrase it, it means that Ukraine has to be torn apart from the rest of the states, from European states. But it's not neutrality anymore, it's just a tool for Ukraine not to be there in Europe. Sorry, I thought that I made up this term disarmed neutrality, and then I saw it in this book, in Shevchenko's book. Yeah, and there is a concept of armed neutrality. Even though Austria and the Switzerland are neutral states, and they are recognized as neutral, but nevertheless they have their armed forces and they produce weapons, and moreover the main export and import of weapons in these states is with NATO countries, and when it comes to weaponization, they are bound with NATO. But nevertheless, they are neutral. What does the Russian Federation say regarding Ukraine? They say that you shouldn't have it. You shouldn't have army. You shouldn't have weapon production. You shouldn't have allies which will support you and protect you. Is it neutrality? It is demilitarization and weakening of Ukraine, complete one and final one. And even the concept of disarmed neutrality allows a state to have armed forces, to produce weapons, and to have the allies who will protect the state, to keep the state neutral. So even when we have even if you're neutral, you have to have the states which will protect your neutrality, because these states will be interested in your neutrality. In our case, that can be only nuclear states, and no one is mentioning that. After mid-20th century, we live in the system of the international community law, where the interests of the community prevail, and that is a common heritage of humanity and many other things, human rights and many others. And therefore, that is the answer to the question why we do not have that many neutral states, and the reason why states do not want to be neutral, to be de jure neutral, but in fact they are not neutral. They have to provide the assistance to the sides, to the parties of the conflict. The right of the international community demands, requires, and most of the states share the principle of the universal jurisdiction, according to which they arrest the military war criminals on their territories, as it happened for a few times, for example, in Germany, the Netherlands, and Finland. How does it work with neutral status? According to the statute of the International Criminal Court, the state is obliged to do that. They are obliged to arrest, to send to trial the Russian criminals. Does it correlate somehow with neutrality? So the right of the international community, which started in mid-20th century, is prevailing here, and in fact it proves that neutrality, permanent neutrality, is outdated institute. So it is historical institute of the international law. As a historian of the international law, it's very interesting to study, but nevertheless it is somewhere in the archives, in higher conventions, which were mentioned today as the last document. The Russian conflict in Ukraine is a classical example of the modern war of the 21st century. The war where two strong states are involved, intellectually, technically, military, and in many other means. Two states, at least Ukraine, is a European state. And there are so many examples which tell us that there is an example of the war where digital tools are used, artificial intelligence, drone wars, and many other things. Lots of things. Ukraine here is facing the gaps in the international law which exists at the moment. Ukraine is collecting the evidence, Ukraine collects facts, and Ukraine can constructively suggest, for example, to improve the international humanitarian law and the right of the armed conflicts and the environment, cultural heritage, and many other things. Ukraine, with these documents, can come up and give the constructive suggestions, but at the same time, being the party to the classical conflict, Ukraine can create a catastrophic precedent for international law and for the future order. If Ukraine will create this precedent when the victim of aggression agrees on conditions of the aggressor state, that will create impossibility to create the new system of collective security in Europe and universal collective security, and the old one has finished already. And that will create a negative precedent for the international law, and it will create some chaos in the international affairs and in all possible conflicts in the future. And therefore, Ukraine has a huge responsibility when we are talking about neutrality as well. Historical principle, historical institutes, and Ukraine doesn't want to return to it. Ukraine, once again, has a huge responsibility as a victim of aggression and as a state which can suggest constructive solutions to the gaps. And finally, I would like to say that I wish it was the end, but I think that when all these demands will be introduced to public, it will mean that, first of all, there is a possibility for negotiations, so that is good. And the second thing is that if it will remain that there are the demands, and in fact the demands might mean that Russian Federation wants Ukrainian capitulation. And I think that we will have this discussion with broader audience, and it will concern media, and we will see it in media, and we will see it in different analytical notes, and I guess Ukrainians understand it much better than politicians. Most people want to be the part of the collective security, even though some time ago people like Shevchenko and the others were playing with it, and they will continue doing that, and they will continue putting bullets to the Russians. And once again, I would like to ask those people who are using the declaration on the state sovereignty. After we have discussed it here, before we had initiative of the 24th of August, and they explained that it was the Soviet Ukraine when we separated from the Soviet Union. And if we will bring back these Russian narratives instead of listening to Ukrainian specialists, it will show that we are repeating the same mistake. So listen to Ukrainians. And today it was a great pleasure for me not only to hear the positions, but to point out the things which we have to pay more attention to, including the suggestions regarding the international law. The ones which we already stated, but it was also interesting, Ms. Olga, your position regarding the things which we did not, which we'll have in the future. I have lots of questions, but I guess that will be for the future discussion. I will be very glad if Ukrainian Association of International Law will be introducing the most interesting professional questions, interesting for people in Ukraine Crisis Media Center and later Ukraine Media Center. Thank you very much. Of course, we will. Thank you, dear participants. Thank you for your attention. Goodbye.